Welcome everybody to the Faculty of Law. So I'm Nessa Lynch and I'm an Associate Professor here at the Faculty of Law, and I'm the Principal Investigator for this research project that has brought our experts here to New Zealand and to do this lunchtime seminar for us. So thanks for a great turnout. So we were debating whether the good weather would mean that there was less people or more people, but thank you all for turning out and giving up your lunchtime. So I'm just going to make a few brief opening remarks and give a little bit of a background on our research project, and then I'm going to hand you over to our experts. So unfortunately we're missing one of our experts from the panel because her travel from Melbourne was disrupted last night. So that's Professor Liz Campbell, but she's on her way and will be joining us for some of our meetings this evening and our workshop tomorrow. But I'm confident that our other three experts will have plenty to talk about, and that I'm sure there'll be some questions from the audience as well. So the first thing that I wanted to do is just to thank our funders. So the Law Foundation of New Zealand, they've been very generous to previous research projects of mine as well. And this particular project, which is in its initial stages, is funded through the Information Law and Policy stream. So that's a particular stream of funding which is designed to promote New Zealand's future digital competence. So it's been going since 2016 and has funded a large range of projects, some of which have come to fruition already, and some of them still to go. So our research team is me, Professor Liz Campbell from Monash, Dr. Martin Betfier from the faculty here, and Dr. Joe Pursehouse from East Anglia University. So we've brought this team together on a project that we're in the initial stages of, which is to examine the automatic facial recognition technology and look at the legal and ethical perimeters of its use in New Zealand. So we started our project just in the winter time in June. So we've got about 4 or 5 aims and research questions for this project. So we're doing a mapping exercise of how the technology is currently being used or may be used around New Zealand, and obviously with some interactions from overseas. We're looking at some of the rights and interests that might be affected by this technology. So obviously the technology has immense value in promoting societal interests such as efficiency and security, but it also represents a threat to some of our individual interests, particularly privacy. So the final part of our project then is looking at potential forms of regulation. So we're assessing what regulation there is at the moment and how it might affect the technology, and then look at what potential forms of regulation might look like. So we hope to produce a final report in mid-2020. So if we haven't connected with you already and you have an interest in this topic, which perhaps you've demonstrated by being here today, would be really happy to speak with you further, and you can get my details obviously on the law school website. All right, so to talk about our format for today, so we're going to have our 3 panelists who will speak in turn. They will speak for up to 10 minutes each. So obviously we've got 3 jurisdictions represented. They'll talk about their particular area of expertise and some lessons perhaps from their jurisdiction. And then we'll open it up for discussion. So our panelists might have some themes to draw out, or we can have some discussion from the audience. So obviously, as you see, the panel is being recorded, so it's not live streaming, but it will be up on the law school website in the next couple of days. So without further ado, then I will introduce our panelists. So they've all got such expertise that if I read out their entire bio, that would probably take up a lot of time, so we'll just do the edited highlights. So in the turn that they're going to speak, so we've got Rachel Dixon, who is the Privacy and Data Deputy Commissioner for Victoria, so in Australia. So she's been in that role since late 2017, and she was previously the Head of Identity at the Commonwealth Digital Transformation Office, and she's held many roles in the private sector as well. So next we've got Dr. Joe Pursehouse, who's a lecturer in criminal law at East Anglia University in the United Kingdom. So he's got some recent research interests in the human rights and the criminal process, particularly privacy. And so he's recently published an article in the Criminal Law Review looking at facial recognition, which no doubt he'll talk about today. So then we've got Claire Garvey, who's visiting us from the Center for Privacy and Technology at Georgetown Law in Washington, D.C. So Claire has been the lead author on a number of that center's reports on face recognition. So she appears regularly in the media on these issues. So she was in the New York Times a couple of days ago. So she's really got that expertise around what's been happening in the United States. So I'm going to invite Rachel up first to address us, and that will be followed by Joe and followed by Claire. So we'll give them about 10 minutes each, let them speak in turn, and then have a little bit of time for discussion.
Thank you very much, Nessa. Can everybody hear me okay? Great. All right. I'm going to talk a little bit, not so much about what's happening in the Australian jurisdiction, because that's actually quite complicated. It's a lot of stuff happening there, but I'll deal with that, I think, in the workshop we're going to have tomorrow. What I wanted to touch on a little bit, because my background before I became involved in the Commonwealth Government and then as the Commissioner in Victoria, was actually in technology, so actually doing a lot of implementation work, actually doing some integration with facial verification systems, etc. And I wanted to talk about some of the use cases, set the scene for some of the other discussion we'll be having. There are essentially two main use cases that people look to for facial recognition. One of them is for essentially verification services, so to match records that already exist with faces that already exist, so to prove that you are who you say you are. That's face verification systems. Then we have facial identification systems, so FIS, and there are two purposes for those. One of them is investigative, and one of them is purely like authenticating and just sort of, so you've done that verification piece where you've enrolled in a particular system where it says, yeah, okay, you are who you say you are, I'm going to give you a credential, right? And then you identify yourself using that credential. Some identification systems are ones you'll be familiar with, like on your phone, for example. You've enrolled yourself on your phone when you first got it, and then later on you use it to identify yourself. You're still using recognition, but it's a different pieces at that point. There are other subsidiary uses. Some of them are very important. One of the use cases that uses a lot of machine learning, for example, is to try and recognize child exploitation. Images involving children. At the moment it has pretty terrible kind of results. It's very hard to do. But there are obviously a lot of use cases that people are interested in from a criminal justice perspective and a harm minimization perspective. For those of you who have not worked with facial recognition, at its heart, it begins with the process of, for example, creating a template of your face. So when you're doing the enrollment part, when you're first providing your face to a system, it makes a template. And you may have seen images of this, which is essentially kind of like it will have lots of little points on your face, and it will sort of draw a little grid. And what it's essentially doing there is pulling out the features from your face. And the algorithm will assign certain confidence levels to those features, so eyes, lips, cheekbones, etc., etc. I sometimes joke that one of the test data sets for, it's not really a joke because it's quite sad, but one of the test data sets that was used very early in facial recognition was a test data set from a county in Florida where they got all of the photographs of convicted felons. And because they're all on meth, the cheekbones are fantastic, so everybody, very easy to recognize. Not actually terribly useful for then training facial recognition on regular people because some of us don't quite have that kind of cheekbone feature. Anyway, moving on. So from those templates, as I said, that feature piece, and that will be interesting, I think, if we go into technology a little bit later in the thing. There are ways of defeating facial recognition that rely on perturbation of those features, not necessarily the templates, but of the actual features. Gentlemen with beards, you're ahead of the curve on that one. So we got the various phases of facial recognition. So the first thing is collecting the image, collecting the images of you. Then we've got when we do the actual recognition bit, there's the detection piece, which is where it matches what the system is feeding it with the stuff that it's already got at the enrollment phase. We have normalization. So that template that's first created is, it's essentially it's a mathematical construct from the features on your face. But of course, your face may be at various angles at various times. And so the normalization piece is to try and take those pieces of the algorithm, of the template that's been created, and adjust them according to what some of those things, what that situational piece might be, to make them conform to the standardized rules for template recognition. Then we have on top of that the actual extraction from that. There are landmarks on your face, as I mentioned before, that those features are defined by. And then we can either, and this is where some different systems and the different handling of systems becomes important jurisdictions, we encrypt those images for security purposes to prevent them from being perhaps used by other systems. In things like fingerprints, for example, some jurisdictions have stored fingerprints, for example, without encrypting their fingerprints. The Philippines did this a number of years ago. When that database was exposed, that was kind of a catastrophe because they kind of had everybody's actual fingerprints as opposed to the encrypted templates of the fingerprints. Now, in the process of making those templates, the system that registers, that does the first enrollment, by the way, may come from a particular vendor, and not all systems are interchangeable. So if you've got a template that's been built by a particular system using a particular algorithm, you can't just take that template and plug it into another system that somebody else has got. In fact, in some cases, even different versions of the system from the same vendor will not be backward compatible. And this has issues for governments implementing these things because you're kind of going into vendor lock-in, which can be an interesting kind of procurement challenge for governments. But it also means that, on the one hand, you've kind of got slightly more security. You can't just hijack a whole bunch of templates and then say, hey, plug them into this handy-dandy facial recognition system I've got over here and reverse engineer them. You would need to apply a fairly high degree of machine learning to actually work on what the features in those templates were, assuming that they're not encrypted. If they're encrypted, you would need the decryption key. And typically decryption is done on the fly by those systems. It's not to say that this makes it invulnerable. Certainly you may have heard about the encryption wars in Australia. Once you have somebody who can decrypt a key, you have effectively everybody who can decrypt the key depending on their level of cleverness. Very quickly, implementation of these systems is hard. The vendors will tell you that this is auto-magical, and that if you buy their system, you'll get these fabulous confidence rates. And for certain use cases, that's true. Most of you have been through smart gates, for example. Smart gates have a relatively low rate of false positives, false negatives relative to some other systems. But the reason they do is they're static. They're installed in particular kind of environments. You can tune them for those environments. They're used for a particular use case. So there's a lot of knowns. And if you'll notice that they ask you to stand in a particular way at a particular angle and look straight on, right? So you're minimizing some of that perturbation of the templates, and that's what creates a greater confidence. By contrast, picking you out walking randomly down the street can be quite challenging. There's a whole bunch of environmental factors there that go to essentially reducing the confidence level. And this is all probabilistic, right? None of this is absolute. There is no one-to-one match that says that this photo is absolutely related to this person. That doesn't exist. And by perturbing an image even a small amount, and the famous things you will have seen, I presume, if you haven't, go on YouTube, look at some of the examples of people, for example, just wearing a little patch underneath their head with some nice colored images on it. And it's been developed by machine learning, and essentially it makes the machine learning and machine recognition system think that in fact the person is not a person. You can make the machine learning system think that the person is a toaster. I'm not joking. I'm absolutely not joking. Because it is all algorithmically based, right? So there are ways to defeat these systems, but I just want to make that point very clearly that we are not talking about absolutes. We are only talking about probabilistic things in a justice context. That's really important, because you may have the wrong person, both from an identification perspective, but also from a verification perspective. Those confidence levels are improved. There's a NIST paper from April 2019, which any of you who are technical may want to get into, which looks at the various confidence scores of the various algorithms that are available. They perform much better for mugshots, for example, and visa photos than they do in the wild. And all of them perform much better in those contexts than in recognition of, say, for example, child porn. So I mentioned we have adversarial attacks, quite easy to do. And the only other thing I would say is that there are lots of there are lots of promises made by vendors in this space. Yes, we will simplify all of these things for you. Yes, we will give you these very high degree of confidence. One of the challenges we have is overcoming the incidences where a false positive is assigned. So I get a match for you as a person of interest. It is very hard to shake somebody's perception that that's wrong after the machine has said it's right. Now, this is true across a whole range of fields. There's a lot of research to show that the first thing that people are told is the thing that they believe. And you can see this in social media. If I give you a poll that says, is Joe Biden a child molester? Well, you've never thought of Joe Biden as a child molester before, but now you've got those two things linked in your brain. And now when somebody says to you, Joe Biden is not a child molester, there's just a little piece. If you can go further, you can plant a lot of other things, and particularly that false positive. This machine has said that you are X, that you are wanted for this, or that worse, you are not this, right? So no coming into this country because you are not the thing that's in your passport. That's a really, really important thing for us to consider. And finally, just the one thing about that, this tool, and the reason for the governance around these tools is so critical, is that one of the non-trivial things for law enforcement in this space, for example, and for domestic violence and a whole raft of other cases, witness protection, is that these tools give people the ability to identify people with legally assumed identities. And that's a profound risk. So for all that law enforcement loves the idea of these tools as a way of solving certain problems, it also creates some profound risks for law enforcement, and that goes directly to governance. I reckon I've hit my full 10 minutes, so I'm going to stop. Thank you.
Okay, thank you everybody, and thank you for being here. I know we're competing with the lovely weather that you've got today. I want to talk not necessarily about the ways in which facial recognition technology should be regulated, the exact rules and the appropriate limits of this technology. I would rather like to focus on a first order question, which is, when faced with a case concerning facial recognition technology, how exacting should judges be? How much should they get involved in assessing whether the use of this technology is appropriate? Should judges carefully scrutinise all the competing values that are at stake between law enforcement priorities and privacy and other human rights? Or should they send that back to Parliament? It might sound intuitive that judges should carefully scrutinise these cases, but there's a debate going on in the sort of senior judiciary of the United Kingdom at the moment, which brings to the fore questions about the separation of powers and the precise role that judges should play in a democratic society. And I think facial recognition technology is a good example case for testing some of the arguments around that. In particular, I'm going to use Lord Sumption's BBC Reef lectures as a jumping off point. If you haven't seen them, I'd recommend watching them. But Lord Sumption might be characterised as someone who takes a narrow view of the courts in the sort of separation of powers between the legislature, executive and the judiciary. His thesis in the Reef lectures and in the book he's published, Trials of the State, which is based on them, is that the law and judge-made law is expanded into almost every corner of human life. Things that used to be considered private matters, such as whether someone should be withdrawn from life support that might be dealt with internally in the family, are now questions of law for judges to decide on. And to summarise Lord Sumption's argument, and I probably won't do it justice in this forum, he basically views some of this expansion of judge-made law as illegitimate. Basically, he views complex moral questions and priorities about resources and things like that, where values come into tension. These are properly the domain of legislators, of parliaments. And this is because For Sumption, parliaments are closer to the public. They're more accountable to the public, and they also have more resources and specialist expertise and committees they can rely upon to establish better policies than judges can, just focusing on limited cases between parties that happen to come before them. In particular, he focuses on the framework for human rights protection in England and Wales as a particular source of expansive judicial lawmaking that is illegitimate and perhaps a threat to our democratic institutions. I'll touch briefly upon that framework. So basically, the UK is a signatory to the European Convention on Human Rights. This is basically an international treaty that sets out fundamental human rights. Most signatories signed up after World War II and the travesties of human rights that were seen there. The UK is a member state, its lawyers had a significant role in drafting the convention, and it basically sets out minimum protections for citizens against the state: a right to life, a right to a fair trial, a right to privacy, and so on. The European Court of Human Rights has the responsibility for interpreting the scope of those rights and making them concrete. People can take their case to the European Court of Human Rights if they feel their government has abused their human rights, and the judges can decide on that. The Human Rights Act gives domestic effect to that convention. So it was drafted and enacted in the year 2000, the Human Rights Act 1998. And basically what Parliament did in enacting this is gave some powers to judges in relation to human rights. Judges can declare statutes or acts of Parliament passed by the legislature as incompatible with the European Convention on Human Rights. They can read statutes in a way that is they feel compatible with human rights, and they can review the actions of public authorities against the convention and the standards that sets forth. Now, for Sumption, this is a problem because it basically transfers the power for lawmaking away from Parliament and into the hands of judges. He stresses that human rights are no bad thing. His problem is more with the method of how we decide the scope of human rights, and he thinks that judges should play a much more limited role than they are at the moment. So that's the basic debate. How does this relate to facial recognition technology? Well, one of Sumption's main points of contention, particularly in his third Reith lecture, is to do with the way the European Convention has been interpreted by the European Court as a living instrument, the living instrument doctrine, which basically says that the provisions in the Convention should evolve with the times. And in particular, he focuses on Article 8 of the Convention. For Sumption, this was originally seen as a protection against secret police activities in authoritarian states, Stasi, Gestapo type activities, and it's actually expanded because the judges have taken a sort of dynamic way of interpreting the convention, and you can see this in Sumption's quote from Trials of the State about the rights that now are read into Article 8, which protects the right to private life. Now, for Sumption, this is sort of judicial legislation. It's illegitimate to go about this. But I think facial recognition serves as a useful case study for defending the way the European Court of Human Rights and domestic courts have interpreted their human rights obligations as they've been given them by Parliament. So, first of all, I'd concede that facial recognition is one of what Sumption would characterise as a polycentric type problem. It's multifaceted. It raises different debates and trade-offs between values, privacy, law enforcement objectives. its cost effectiveness is something that reasonable people could disagree on. But I don't think that that necessarily means that we should leave it to Parliament to decide the appropriate limits on facial recognition. Now, I should stress that Lord Sumption hasn't ruled on a facial recognition case. We shouldn't second guess that he would disagree with me on this. But I think it's a polycentric problem. It might be one that he would view as an encroachment if it was dealt with as a human right by the courts. So 3 prongs to my sort of defence of the courts taking an exacting analysis of the scope of Article 8 in the context of facial recognition cases. First, I think evolutive interpretation is defensible because otherwise Article 8 wouldn't really have much meaningfulness or effectiveness in a modern society. The drafters of the convention in the 1950s couldn't have really known about facial recognition technology and how this would impact upon human rights. And also our understanding of private life and the plain meaning of that term will naturally change as society changes and technology advances. So whereas in 1950 the private life might have been well enough protected by protecting someone in their home or in their place of work or protecting their correspondence, something like facial recognition disrupts that understanding of the nature of privacy as an interest and its value. If the police can biometrically process information about people and do all the things that Rachel talked about in her presentation, when people are occupying public space, then it raises questions about the changing meaning of what it is to have a private life and to have a private life respected by the state. And I think you need some evolution to really recognise and give effect to that. Second, Sumption does a really good job of talking about the advantages of the electorate and elected representatives in their accountability and their ability to take a broad view of problems. But what he perhaps plays down are some of the strengths of the judiciary as a junior partner in the task of governing. What judges lack in accountability, they might make up for in their independence. Now, facial recognition technology, we've seen in the trials of this technology by the police that it tends to affect marginalised communities that might struggle to get their voice heard in the normal democratic process. Suspects of crime, people from lower socio-economic status who are forced to use public space and rely more heavily on public space than people who have economic advantages, perhaps. So judges have an independence that the legislator perhaps doesn't. And we've seen this in criminological research time and time again. There's many people have written on this type of thing, that legislators are close to the electorate, and sometimes that can not only be a virtue but a vice. Populist concerns. It's no secret that politicians can gain easy electoral capital by appearing tough on crime, by being the party of law and order. So there's advantage in sort of just giving police tools, giving police or state security services wide expansive powers. It might be useful to give judges some discretion and some independent robustness to evaluate what parliaments are doing in this space, but also harnessing general principles to more concrete cases. When parliaments draft sort of general principles around data protection or around the collection of criminal evidence, they can't necessarily foresee all of the consequences of that. Whereas when cases come before courts, they can. So it's not necessarily adequate to just kick questions and complex issues back to parliaments. Third and finally, I'll keep it quick because I feel I may have run on a bit. This isn't necessarily as illegitimate as some might suggest, and as Sumption perhaps suggests in trials of the state. Parliament enacted the Human Rights Act and entrenched human rights protections and gave the judiciary these powers to interpret the convention. They knew it was a dynamic treaty at the time, and they could repeal the Human Rights Act and face the consequences of that if they wanted to. They could also ignore particular cases where a statute has been declared incompatible or a government's actions have been deemed to be contrary to the convention. So, in short, my argument is that when faced with facial recognition cases in particular, and judges are beginning to have to grapple with these cases, they shouldn't shy away from taking a broad view of competing values that are at stake and evaluating the costs and benefits of its uses and the quality of legal frameworks in place. Thank you.
Hi everyone, very happy to be here. For those in the back, if my voice drops at all, which it tends to do, just give me some sort of nod letting me know that you can't hear me. I'm going to provide the very, very brief overview of the US experience with face recognition, focusing particularly on law enforcement. That's not to say that the commercial space in the US has not been adopting face recognition in a very, very broad and widespread manner, but my research focuses on public agency use. In the United States, face recognition is very, very common. It's a very common tool used by law enforcement agencies as an investigative tool. What I mean by as an investigative tool is it's used very much as one would use latent fingerprint technology. One can imagine faces captured on camera, on video cameras, or anywhere a face may be captured on in photographs or videos as a latent face that can be transferred into a face template, as we heard earlier, and compared against a database of known entities. Typically in the United States, that's mugshot databases or databases of arrestees. Increasingly, it's driver's license photo databases to try to find a match. U.S. law enforcement agencies are very keen on adopting face recognition as a surveillance tool as well, the ability to attach the technology to surveillance footage and or live CCTV footage and try to identify either anybody walking by a camera or to look for a certain person in a crowd. But the primary use in the U.S. is investigative. As I mentioned, it's very common. We estimate conservatively that a quarter of all law enforcement agencies in the United States, of which there are about 18,000, have access to a face recognition system, either by directly purchasing it or accessing someone else's system. That's a very conservative estimate. It is likely much broader than that. The oldest known system that we're aware of was implemented in 2001. So this technology has been around for almost 20 years in the United States. I mentioned driver's license databases. We know now that over half of all American adults are enrolled in a database that's accessible for criminal investigations thanks to getting a driver's license. This is not something that most Americans are aware of, but it now covers most American adults. There are no rules when it comes to the use of face recognition by public agencies in the United States. With very, very few exceptions, there are no laws that govern the use of this technology either at the federal level or state and local levels. Much as in New Zealand, no laws expressly touch on face recognition with very few exceptions. As a result, this technology has been implemented largely without transparency to the public, without rules around auditing or public reporting, without rules around who can be subject to a search. As a consequence, it is not just suspects of a criminal investigation that are the subject of searches. In many, many jurisdictions, witnesses, victims, or anybody remotely associated with a criminal investigation can also be the subject of a search. In our research, we found that this includes the girlfriend of a suspected fugitive, somebody who liked a suspect's photo on Facebook, somebody who asked suspicious questions at a gun store. I don't know what suspicious questions at a gun store are. I think most questions at a gun store are probably suspicious to some degree, but that can make you subject to a face recognition search. I mentioned no audits. This means many agencies who use this technology are never checking to see not only whether it's being misused, but whether it's actually a successful tool, whether they are catching bad guys with this tool, or whether it's actually a colossal waste of money, which in some jurisdictions I suspect it is. The one arguable check against this very unregulated use of the technology in the US is the fact that most agencies consider it an investigative lead only, meaning that they can't make an arrest solely on the basis of a face recognition match. This is intuitive. Most systems do not produce just a binary, this is Joe or it's not Joe or it's nobody type of match. They produce a candidate list, a list of possible matches. This in theory sounds like a good thing. It means that a human has to verify whether there is a match. In reality, what this means is that the human making this choice, unlike in forensic fingerprint science, is an analyst who is not certified in forensic face identification. There's no such thing as certification in the United States around what that means, what sort of training you have to get to make that type of identification. We like to think we're very good at doing this type of identification. We all look at each other and recognize each other. We're very good when it comes to people we know and very not good at recognizing people we don't know. So as a consequence, this actually introduces the more potential for error into the systems. The issues or legal questions that are raised and the ones that are very much at the forefront of the discussion in the United States hinge around what we call our First Amendment rights. In human rights speak, that's free speech, assembly, association. Face recognition has been used on protests in the United States. We know of one example in Baltimore, in Maryland, where a protest around police treatment of people in custody was subject to face recognition surveillance. Law enforcement agencies themselves have said this creates a very real risk of people being chilled, people not feeling comfortable participating in public protest or public speech, particularly contentious speech, particularly speech that calls into question police activity, and yet it does happen and there are no practical restrictions against it. The right to privacy, as we've heard a lot about, so I'm actually going to skip that, but happy to take questions about that. The other two aspects where there are legal or societal questions raised is the right to due process in the United States, the right to a fair trial. In the US, under a case called Brady, we have this idea where a defendant is entitled to potentially exculpatory information from the prosecution, information that speaks to his guilt or innocence. Face recognition produces quintessentially exculpatory information. As I mentioned before, it produces candidate lists. Well, let's take the NYPD, the New York Police Department, for example. They have their candidate list set to, their face recognition set to return a minimum of 200 possible matches to the analyst, who then reviews all of those and decides whether there's a match. There's a case where they decided the 319th person in that list, which is rank order from where the algorithm thinks is most likely to least likely. They thought number 319 was the person to investigate and then later arrest, which means the algorithm thought 318 photos looked more like the suspect than the person they actually ended up arresting. That is quintessentially exculpatory evidence. It is never turned over to the defense. Moreover, it is not uncommon for law enforcement agents in the US to edit the photos before submitting them to search. If we think of this as a biometric, it's an imperfect biometric. There are a lot of questions about whether it is a biometric. This amounts to either the fabrication of evidence or the intentional contamination of a biometric sample before submitting it to search. Again, to pick on the New York Police Department because we litigate against them, and they've been dragging out this litigation for 2.5 years, and it takes up a lot of my time. They have done the following. They have cut and pasted other people's eyes into their suspect photographs when the eyes are closed. Same with somebody's mouth was obscured. They went on Googled black male model because their suspect was black, cut and pasted the person's mouth that they found, some model's mouth, into their suspect photograph before running it through their face recognition system. They do face normalization, as we heard earlier, taking a face that's partially obscured, rotating it to face front, papering in what the missing part of the face looks like based on an approximation of what the average face looks like and what the visible part looks like, because we all have perfectly symmetrical features, obviously. Law enforcement agencies in the US submit forensic sketches, drawings of faces to these systems, despite overwhelming evidence that this will fail pretty much all the time. They also submit, the NYPD submits what they call celebrity lookalikes to their face recognition system, the exact wrong person expecting the right result. The case that we found is they used the actor Woody Harrelson in place of this guy that was suspected of stealing a few beers from a CVS. And they ended up making an arrest based on Woody Harrelson's lookalike in their mugshot database. To my knowledge, Woody Harrelson has not been arrested in the United States, and he was not the person stealing beer from the CVS, but I could be wrong. I think I've gone over time, but in the last minute, there have been, over the last 6 months, a number of efforts to regulate face recognition in the United States, taking into account all these issues, as well as what I did not mention, inaccuracies in the fact that these systems still perform less accurately on certain people. They perform differently depending on your race, gender, and age. The efforts to regulate have ranged from outright bans on the use of the technology by law enforcement. We see this in San Francisco, in California. Berkeley just last night approved a ban, Somerville, Massachusetts, so small jurisdictions. There have been a number of moratoria or regulatory efforts in states, and then some hints at something like that. At the federal level, we're not optimistic that anything's going to happen at the federal level. So as a consequence, what will likely happen in the United States is a very piecemeal jurisdictional approach to regulating the use of face recognition, where people's rights to privacy, to peaceful assembly, to free speech, to due process is going to vary, not only by the jurisdiction they live in, but by which agent happens to arrest them. So in San Francisco, for example, if the police arrest you, they can't use face recognition. If the sheriff arrests you, who has concurrent jurisdiction, they can use face recognition. This is going to be a disaster, but that's the approach that seems likely at this point in time. I'll end it there because I like ending on really dark notes. Thank you.
So I think we'll bring formal proceedings to a close, as I know people will have other meetings to get to. But thank you so much for coming out, and it's really good to see the level of interest in this topic. So as I said, if you have an interest, please feel free to contact me. So we'll be writing this report as a team up until mid next year, and we'd really like to hear from people. And I'm sure we'll have a bit more of a public event as well once we get more advanced in our research. So thanks again for coming out, and thanks to our speakers.